Hello everyone and welcome to our podcast. Today we are going to discuss an important topic in international law, which is can a state use its domestic law to avoid international responsibility. I'm Yumi.
Hello everyone, I'm HAIZAL.
And I'm KADIZAH. This topic is important because conflict between the domestic law and international obligation happen more often than we think.
So that's right. Let's start with the basic question. Can a state simply say our domestic law doesn't allow us to do this and then avoid responsibility under the international law?
Alright, the short answer is no. Why? Because under international law, the state cannot rely on its domestic law to avoid international responsibility.
That's interesting. Why doesn't international law allow that?
Well, international law is based on the principle that states must handle the commitments they voluntarily accept. If countries could simply change their domestic law whenever they want to avoid an obligation, international agreement will become meaningless.
Exactly. There is also an important legal principle called Acta Sans Servanda, which means agreement must be kept.
So once a country signs and ratifies a treaty, it is expected to follow it in a good faith.
Yes, that's correct.
In fact, in Article 27 of the Vienna Convention of the Law of Treaties clearly states that the state may not involve its internal law as justification for failing to perform a treaty.
In simple terms, if a country agrees to a treaty, it cannot later say our domestic law doesn't allow us to comply and expect to avoid the responsibility.
So, the state must make sure its domestic law are consistent with its international commitments.
That's right.
So let's look at an example. Imagine a state ratified an international human rights treaty that prohibited torture.
But what if the state domestic law allows certain integration methods that are considered torture under international law?
In this situation, the state will still be internationally responsible if these methods were used. It cannot defend itself by saying that its domestic law permits such actions.
That's because international responsibility is assessed according to international law, not the domestic law.
That makes sense. Otherwise, countries would avoid responsibility whenever they want it.
Exactly, and that's one reason why this principle is so important. It promotes trust and stability in international relations.
So think about environmental agreements, trade agreements, or human rights treaties. This agreement only if states actually respect to their commitments.
So if every country could simply pass a conflicting domestic law, international cooperation would become more valuable.
That's correct. Countries need confidence that other states will handle the obligation they have accepted.
Are there any exceptions for this rule?
Actually, there are a few limited exceptions. For example, under the Article 46 of the Vienna Convention, a state may challenge its consent to a treaty if there was a clear violation of a fundamental constitutional rule regarding about the authority to conclude the treaties.
However, such cases are rare. In most situations, domestic law cannot be used to avoid international responsibility.
So, to conclude, a state cannot rely on its domestic law as an excuse for failing to fulfill its international obligations.
International law requires states to respect the treaties and commitments they have accepted.
And this principle helps to maintain the accountability, trust, and cooperation among the nation.
Thank you for listening our podcast.
We hope this discussion has helped you better understand the relation between domestic law and international responsibility. Thank you.
Thank you and goodbye.
I just had to let you know you're